Good evening, friends. When you have a senior counsel like Jayakumar S Patil from Karnataka High Court, you are bound to be sure that the knowledge which you share would actually expand your mind. And the topic for today is the right of property, unlocking facts and law. But at least I can say that whatever today he shares, that will be a property for you, which you will cherish for all times to come. We are also thankful to Trikram and Associates who have been with us in this journey of legal sharing. Before Mr. Jayakumar Patil takes over the baton, I will request Trikram to just give a brief introduction of Mr. Patil.
Thank you very much, Vikas Chatrat sir. Jayakumar S Patil sir needs no introduction. He is already on board and he has delivered so many talks on this forum. And we are so fortunate today to have him on this platform. Sir, on my personal behalf and on behalf of Beyond Law CLC and all our audience from Bangalore as well as Pan India, I extend a very warm welcome to you, sir. Over to you. Sir, you are muted. Vikas sir, I think you should unmute Jayakumar S Patil sir.
Thank you, sir. Today's topic, as my friends already said, is right to property, particularly the recent trends about the right to property. This topic, actually this lecture, I had presented it as a paper in the Justice Justice G.N. Sabait Memorial Lecture. Actually, I had presented that. And I think with a little addition of recent this thing, I'm presenting the same paper. The property in the rudimentary or raw sense is everything which someone is having and everybody else wants to have it. The property in all its embracing meaning can be anything which can be traded in the market, including the real money in the pocket, kept in deposit in a bank. If we are to exclude a minuscule minority or the so-called non-existent philosophers who are not attached to property, every one of us, whether poor, middle class, rich, or super rich, have great longing and attachment for property. From time immemorial, it is property and its ownership or possession which has determined the status of a person in India as well as all over the world. It was cattle to begin with, domesticated animals, thereafter real sense property, that is land, gold, silver, precious stones, and above all, offices of power over others. Before proceeding further, I must mention that every statement in this article is an extract or referable to one or the other judgments of the Supreme Court or from articles by great men like Nani Palkiwala and Justice K.K. Matthew and others. I am totally indebted to the authors of the judgment and these articles. I am sure a votary of the school of thought which says that every action, reaction, relationship of human beings, relationship between the nations, states is basically determined by economics. Therefore, every other right or freedom of the man in the society, the quality, quantity of such rights and freedom and exercise and enforcement ability of such rights and freedom is totally connected to economic standards, which are primarily dependent on right to property. No discussion or deliberation on right to property can be complete without reference to the statements and writings of that great thinker and economist, greatest lawyer of our time, Shri Nani Palkiwala. In an article in the Freedom First issue of February 1971, I am quoting, "The right to property is often derided as least defensible right in a socialist democracy, yet a little reflection should show that this right is of essence of a sound body politics and of a democracy which aims at matching forward economically. Any attempt to abrogate fundamental right to property would be erroneous because it would run counter to the eternal laws of human nature." Jefferson, former president of America, said, "Liberty cannot long subsist without the support of property. Property must be secured, else liberty cannot subsist," was the opinion of John Adams. The freedom of speech and expression, freedom of religious practices, freedom of association, freedom of travel, freedom to profess trade, business, and occupation will not have any meaning to the common man. He will not be able to enjoy or exercise any of these freedom unless he is supported by some property in his possession on which he can always fall back. It is this property and its preservation which gives him this strength to stand up. Any action which threatens, deprives him of property right, or possibility or apprehension of deprivation of property rights will have a chilling effect on his existence itself, let alone the other rights and freedom. It is in this background the right to acquire, hold, and dispose of the property was declared as fundamental right, along with right to freedom of speech and expression, right to assemble peacefully without arms, right to form association or unions, to move freely throughout the territory of India, to reside and settle in any part of India, to practice any profession, trade, or business under Article 19 in Part 3 under the heading of fundamental rights in our Constitution. It may be noted that right to property was equated with all other exalted rights of citizens of India. By this declaration, the rights which are inherent in every human being are recognized as freedom necessary in a civilized society. Of course, all these freedoms and rights are made subject to certain restrictions in the interest of the nation, state, and the society, as provided under Article 19(2) to 6. Then again, restraint is specifically enacted against the state in respect of right to property by the provisions of Article 31. In a way, Article 31 puts further limitation on the right to hold, acquire, and dispose the property guaranteed under 19(1)(f), subject to reasonable restriction under Article 19(5), with respect to interest of the general public for protection of interest of any scheduled tribe. Article 31 referred to the citizens as well as non-citizens, and Article 31 enables the state to deprive any person of his property, provided such acquisition or requisition is for public purpose and compensation is paid. The enabling provision under Article 31(2) for the state to acquire and requisition the property subject to payment of compensation was amended by the Constitution 24th by Act 24 of 1951, particularly as the state was finding it difficult to enact laws pertaining to agrarian reforms, particularly Jamindari abolition, village office abolition, etc., resulting in amendment of Article 31(2) as well as addition of Article 31A and B, apart from diluting the right to property. The main aim was to dilute the provision for payment of compensation. It may be noted that compensation, it was held by Supreme Court, means adequate and just value and referable to the market value. By Article 31A, the validity of law providing for acquisition and payment of compensation was put beyond the challenge on the ground of Article 14 and 19. Article 31B made a further provision. Legislations put under 9th schedule shall be beyond the test of validity on the ground of violation of fundamental rights. Further, the amendment was made to Article 31(2), substituting the word amount for word compensation. Thereby, even the payment of compensation and reasonableness of quantum was also diluted. In spite of it, courts took the view that though the word amount is substituted for compensation, and in spite of Article 31A and B, it was held that word amount cannot result in compensation being illusory or no compensation at all. In spite of the fact that right to property as a fundamental right was reduced to nominal fundamental right, further amendment was made to Article 31A and Article 31C was inserted by successive amendments, 17th Amendment Act and 25th Amendment Act. By Article 31C, it is provided that laws made for giving effect to directive principles under Article 39B and C were put beyond the realm of challenge on the ground of violation of any fundamental right. It is also further provided that declaration that law is made for giving effect to directive principles under Article 39B and C is beyond judicial review. Thus, by 1971, the only protection regarding the property was agricultural land that remained in the second proviso to Article 31A. It provides for any law made for acquisition of land held by a person under his personal cultivation, which is within the ceiling limit prescribed under any law, cannot be acquired unless market value. Such law provides for payment of compensation at a rate which is not less than the market value. All these amendments affecting the right to property came up for judicial review several times and ultimately in the famous case of Keshwananda Bharati. In the case of Keshwananda Bharati, it was interpreted that amending power of the parliament will not extend to changing the basic structure of the constitution. But in this very case, it was further held that right to property is not one of the basic structures of the constitution. Therefore, the amending power of the state which extends to amendment of the fundamental right can amend fundamental right to property, thus in a way giving permission to do away with the right to property as fundamental right. In 1971, Article 31C was further amended. The law providing for giving effect to all or any of the directive principles were put beyond the power of challenge and judicial review, even to the extent of validity of such declaration as to the law being one for giving effect to the fundamental rights. Of course, the second part of Article 31C, doing away with the judicial review, was declared as unconstitutional in the famous case of Minerva Mills. Thus, the right to property in its most degenerated form had still remained as Article 19(1)(f) and second proviso to Article 31(a) in the Fundamental Rights chapter. In an euphoria, when Janata government came to power after emergency, by 44th Amendment of Amendment Act 1978, with effect from 20th June 1979, Article 19(1)(f) was deleted and Article 31 was deleted. Thus, the right to property, to hold, acquire, and dispose the property, and some vestige of restraint on the state from depriving any person of his property was totally taken out of the chapter of fundamental rights. By the same 44th Amendment, Article 300 capital A, Article 300A was inserted, which reads as follows. The person not to be deprived of the property save by authority of law. No person shall be deprived of his property save by authority of law. Thus, the most debated, decried right to property ceased to be a fundamental right. Thereby, deprivation of property cannot be a subject matter of judicial review under Article 32, as it is no more a basic or fundamental right. As on today, the only protection with regard to agricultural property from acquisition is under second proviso to Article 31(a), to the extent that for acquisition of such agricultural land under personal cultivation, state is under an obligation to pay compensation equivalent to the market value. In a lighter vein, it is said, why only property, even the person owning the property can be acquired, so that payment of compensation becomes redundant. Property as seed bed of all other rights. The emerging trend regarding right to property till about the year 2000 was that any law which violates fundamental right or any constitutional provision is liable to be struck down. Therefore, any law violating constitutional right under Article 300(a) will be struck down, forgetting the fact that Article 31(a), 31(b), and 31(c) are retained in Part 3 of the Fundamental Rights chapter. The discussion in the academic circle across the country and in the bar viewed that 44th Amendment was a hurried action. Constitution Amendment Bill was not even referred to Select Committee. The election manifesto of the then Janata Party was to remove the fundamental right from the property as fundamental right, but simultaneously to introduce right to work. In a hurry, first part of the manifesto was given effect to without fulfilling the corresponding promise of guarantee of right to work. Further discussions now started, particularly after the collapse of USSR and the triumph of liberal economy, about human rights. It is this emerging trend of thought and how it has made entry to the judicial thoughts and decisions of the Supreme Court and the High Courts is very interesting. Before referring to human right, we may as well remember that acquisition of property, sealing law, etc., enacted by competent legislature cannot be challenged on the ground of violation of right to life and liberty under Article 21, as held by the Supreme Court in the case of Basanti Bai Khetan. The word law, as occurring in Article 300(a), which is similar to Article 265, that is taxing power, is referable to validly enacted legislative provision as held in the case of KT Plantation versus State of Karnataka. Different views were put forth in academic circles, particularly in seminars and conferences, law universities where lawyers were main participants about the effect of deletion of 19(1)(f) and 31 and insertion of Article 300A by 44th Constitution Amendment. One argument is right to property means a constitutional right under Article 300A, but the legislative entry 42 to acquire and requisition the property remain the same entry in list 3 of 7th schedule as it stood prior to 44th Amendment. Therefore, any acquisition by state can only be on payment of compensation. Even senior lawyer Fali Nariman also took the view that it is said by the words by authority of law used in Article 300A are significant because these words in effect bring in due process of law or rule of law. Rule of law being basic structure of the Constitution, any action contrary to rule of law is not valid. The word authority of law means legislative enactment, not executive order, as same expression is used in Article 265 and Article 300A is already held as legislative enactment. Any law which provides for appropriation of property without compensation will be ex facie arbitrary, violative of Article 14 and rule of law. I am not for a moment testing the validity of these viewpoints. Another view is one cannot equate or place on higher pedestal the right under Article 300A than what it was when it was under Article 19(1)(f) and Article 31, forming part of fundamental rights. This argument draws support of the fact that though Article 19(1)(f) and Article 31 are deleted, Article 31A, 31B, and 31C continue to be in Part 3 of the Fundamental Rights chapter. Therefore, any law, legislative enactment, acquiring the property by competent legislature without providing for compensation will be valid law, and courts cannot strike down such law on any ground, sole exception being property protected under Article 31A proviso. As even prior to the amendment, adequacy of compensation, to be precise, adequacy of the amount was put outside the purview of the judicial review. Before proceeding further, to examine the precarious position of right to property as it now exists under our Constitution, one important judgment which I referred to earlier in the case of Basanti Bai, reported in AR 1986, Supreme Court 1466. Supreme Court held that challenge to validity of particular act providing for acquisition cannot be struck down by invoking Article 21, guaranteeing the life and personal liberty. Para 16 of the said judgment reads as follows. Then in the end, we have to consider the argument based on Article 21 of the Constitution, which is urged on behalf of the respondents. Article 21 essentially deals with personal liberty. It has little to do with right to own property as such. Hence, we are not concerned with a case where the deprivation of property would lead to deprivation of life or liberty or livelihood. On the other hand, land is being acquired to improve the living conditions of large number of people. To rely upon Article 21 of the Constitution for striking down the provisions of the Act amounts to a clear misapplication of the doctrine enshrined in Article 21. We have no hesitation in rejecting the argument. Land ceiling laws, law providing for acquisition of land, for providing housing accommodation, laws imposing ceiling on urban property, etc., cannot be struck down by invoking Article 21 of the Constitution. Now, human right. India is signatory to International Covenant of Economic, Social and Cultural Rights 1966. Article 11 of the covenant reads as follows. The state parties to the present covenant recognize the right to everyone to adequate standards of living for himself and his family, including food, clothing, and housing. The Protection of Human Rights Act 1993, enacted to implement the aforesaid international covenants, defines the human rights and international covenant as Section 2D. Human rights means rights relating to life, liberty, equality, and, mark the word, dignity of the individual, guaranteed by the Constitution or embedded in the international covenants and enforceable by courts of India. Section 2F defines international covenants. International covenants means International Covenant on Civil and Political Rights, International Covenant on Economic, Social, and Cultural Rights, adopted by the General Assembly of the United Nations on the 16th December 1966, and such other covenants or conventions adopted by the General Assembly of the United Nations as central government may by notification specify. The Covenant on Economic, Social, and Cultural Rights 1966 is specifically recognized under Section 2F of Human Rights Act. In the case of Munichikkanna Reddy, Supreme Court refers to the Universal Declaration of Human Rights. Universal Declaration of Human Rights 1948 provides under Section 17I, everyone has the right to own property alone as well as in association with others. No one shall be arbitrarily deprived of his property. Further reference is also made to Declaration of Rights of Man and Citizen 1789. Supreme Court further held that right to property is also considered very much part of multifaceted dimensions of human rights. Paragraph 43 reads as follows. It is in Munichikkanna case. Human rights have been historically considered in the realm of individual rights such as right to health, right to livelihood, right to shelter and employment, etc. But now human rights are gaining multifaceted dimensions. Right to property is also considered very much part of the new dimension. Therefore, even a claim of adverse possession has to be read in that context. The activist approach of English courts is quite visible from the decision in Violin Properties versus Palmer. The court herein tried to read human rights possession in the context of adverse possession. But what is commendable is that the dimensions of human rights have been widened so much that now property dispute issues are also being raised within the contours of human rights. Supreme Court further held that right to property is also considered very much part of multifaceted dimensions of human rights. Referring to several earlier judgments in the matter of deprivation of property without resorting to acquisition, in the case of Tukaram Khana Joshi, paragraph 7, it reads as follows. The right to property is now considered to be not only constitutional or a statutory right, but also as human right. Though it is not a basic feature of the Constitution or a fundamental right, human rights are considered to be in the realm of individual rights such as right to health, right to livelihood, right to shelter and employment, etc. Now, however, human rights are gaining an even greater multifaceted dimension. The right to property is considered very much to be a part of such new dimension. There are several other cases where the Supreme Court referred or held that right to property is not only constitutional, legal, statutory right, but is also human right. In the case of Francis Corelli, Delhi versus Union Territory of Delhi, Supreme Court held, in a long line of cases while considering the right to life and personal liberty, the courts, particularly Supreme Court, have held that life, as mentioned in Article 21, includes to live with human dignity. In Volga Tellis versus Bombay Municipal Corporation, right to livelihood is integral part of right to life. That which about makes it possible to live, leave aside what makes a life livable, must be deemed to be an integral part and component of right to life. Again, bringing it somewhere near about Article 21. The right to livelihood necessarily includes a means to earn livelihood where property in some form or the other steps in, because in the case of Chameli Singh, it was held in an organized society, right to live as a human being is not ensured by meeting only animal needs of man, but it is secured only when he is assured of all facilities to develop himself and is freed from restrictions which inhibit his growth. Paragraph 28 further reads, in Subara versus District Collector, Andhra Pradesh High Court, considering the obligation of the state to provide shelter to weaker sections of the society by acquiring lands for public purpose and distribution thereof, has held that in all stages of social development, a man must have some property or capacity to earn some property. The emerging trend, which is accepted by constitutional courts, particularly from 2000 onwards, that right to property is part of human right, and the human right differently part of right to life and personal liberty guaranteed under Article 21 of the Constitution. Justice K.K. Matthew, in his treatise on democracy, equality, and freedom, has elaborately dealt with right to property and its interrelation with personal liberty, with democracy, and with civilized society. And above all, possession of property which gives the power over lives of others, and also the interrelation and subsistence required for exercising all the basic fundamental rights guaranteed under our Constitution. The emerging trend now is bringing right to property under human rights covered under right to life and liberty. In the ever-expanding dimensions of right to life and liberty, it is implicit that adequate living standards is one of the major ingredients so as to ensure an opportunity to fully develop and express himself. Initially, the cases before the Supreme Court pertained to right to shelter or housing. The right to shelter or housing, with all its basic incidents, was accepted as human right, which is part of right to life and liberty enshrined in Article 21, in effect making it a part of fundamental right under Article 21. The emerging trend about right to shelter, education, access to work, access to clean water, food, environment is taken a step forward would include right to property. Of course, this is not something of a new argument coming up after the 44th Amendment. Political thinkers, including socialists and several statesmen, have always advocated right to property as basic right or natural right, or at least a necessity in a society for economic progress and individual creative spirit. It is without the incentive of right to property, there will be no creative economic activities, invention, discovery, and enterprise at the individual level. Therefore, some reward by way of right to property is a must for progress of the individual and through him, progress of the society. In another recent judgment, Vidya Devi versus State of Himachal Pradesh, again pertaining to acquiring of property, Supreme Court referred to observation of Delhi Air Tech and held it is accepted in every jurisprudence and by different political thinkers that some amount of property right is an indispensable safeguard against the tyranny and economic oppression by the government. Indeed, view that property itself is the seedbed which must be conserved if other constitutional values are to flourish is the consensus among the political thinkers and jurists. In Jilubai case, Supreme Court held as follows. In other words, Article 300A only limits the power of the state that no person shall be deprived of his property save by authority of law. There has to be no deprivation without any sanction of law. Deprivation by any other mode is not acquisition or taking possession under Article 300A. In other words, if there is no law, there can be no deprivation of property. Futuristic trends. Thus, the emerging trend is to refer to right to property as a human right, thereby making it in an inalienable basic natural right of the human being. We will have to now wait and watch how and whether Supreme Court will be persuaded to officially treat it as part of right to life and personal liberty under Article 21 of the Constitution. But all these cases and arguments are referable to property in the traditional sense, that is, real-time property, tangible property. But time and again, the property changes its color, changes its nature. Right to employment may be a property. The license to practice as doctor, advocate, architect may be property. For a cab driver, driving license itself is property. In not so far away future, all work will be done by artificial intelligence, and therefore nobody will be doing any work, and hence a share in the company controlling the artificial intelligence or in the social security or other amount paid by company owning or controlling artificial intelligence will be the property. The necessity of property in some form or the other is indispensable for human being to live in an organized society so that all his faculties and creative instincts get the full opportunity to bloom in all its splendor. It also cannot be glossed over that the possession and control over property gives power to control the lives of other people. Ultimately, a share or access to political power, whether it is democracy, capitalism, communism, or any other form of government, is also property, and right to property steps in. Those who hold property will be minuscule minority compared to those who have nothing to lose. Therefore, society always finds a way to change the equation. Take back the property to the society by legal means or by illegal means, violent or otherwise, as has happened historically. By revolution, properties are taken away, kingdoms are toppled, a different setup of governance is established. The property as material resources, I will respectfully submit with all its ills and evils attached, still the property as a just reward for one's efforts, enterprise and creative instinct is necessary and is basic to human being and is essential for human being to create and develop a just society and above all ensure dignity of the individual. The property as material resources of the community under Article 39B and C. The property, the accumulation of which gives control over means of production, gives power over lives of other people. The property as human right is the seed bed of all other rights. The very concept of property as understood today may become irrelevant. The property rights, copyrights, trademark, patent, but still these rights have connection to tangible property. In a short span, life will be dictated, directed by artificial intelligence. The artificial intelligence will be controlled and owned by multinational corporate bodies. Therefore, territorial laws, even constitution, cannot guarantee or take away the right, let alone right to property. It is really mind-boggling to think about a jurisprudential answer, a measure to prevent enslavery of human being to artificial intelligence technology, which will hold all the property in the globe. I think and believe formation of society or societal living started introducing rudimentary customs and slowly concept of rule of law. The one who gained by personal valor or effort property could hold on to it so long as he remained personally strong and physically powerful. Therefore, initially protecting the property itself was a huge task. It is under these circumstances, people through society invented custom, law, etc., ensuring protection of right to property, introducing rule of law. This will remain a requirement eternally so long as human being remains. In India, after deletion of 19(1)(f), right to property from the Fundamental Rights chapter, we had a golden opportunity when Constitutional Review Committee was looking into the matter with regard to whatever requirement or amendments are required for the property. The Constitution Review Committee, headed by Chief Justice M.N. Venkatachalaya, it's a million-dollar question, at least for me. What made the review committee not to recommend to restore the fundamental right to its original place at 19(1)(f)? But one thing is certain, the right to property, in whatever manner they take away, it still remains as the basic requirement for living, a creative instinct for a human being. Hence, the right to property will have a way of mocking at society and the laws which want to do away with the right to property. So I shall, at the article stage, I shall stop at this. I'm told this article will be put in the YouTube so that these citations which I referred are given in the article with reference to reported judgments. Thank you, sir. Over to Vikrant. Over to
Yes, sir. Like you rightly said that we would be sharing our the judgments by you, including the articles on our website. So those who want the judgments, we will share it shortly on our website. And thank you, sir, for sharing your knowledge. It is always such a pleasure to hear you. I'll also ask Vikram to share his expressions. Vikram, unmute. Vikram. Vikram. Yeah, over to you, Vikram.
Sir, thank you so much, sir. It was a stupendous presentation. In detail, you have dealt with the subject matter, sir. And I would also like to take this opportunity to welcome our senior advocate, Shri P.P. Hegde, sir. He's also joined the webinar. Sir, can I request you to also switch on the video, sir?
Home.
P.P. Hegde, sir. He has switched on the video. I think you should allow him to unmute also.
P.P. Hegde. So you will have to unmute yourself, Mr. Hegde.
You have not given the option, I think.
No, we have given it. P.P. Hegde.
Yes, yes. It is wonderful speaking to Sri Jayakumar Patil. I had also great knowledge acquired now by listening to him. It's a great opportunity. Thank you for giving the opportunity to all of us. Probably many are sitting in different states. We are listening. It's wonderful. And share the entire text also and share it in YouTube. We'll be able to rehear again. Thank you.
Mr. Hegde, we are already live on the YouTube. That session is already uploaded on the YouTube.
It's wonderful. It's a wonderful idea. And a very good thoughts from Sri Patil as to why in the 44th amendment, 42nd was not undone. I also did not know. Sri Amanda Venkatachala headed it and did not report back for reintroduction of the 42nd misery, which would have been undone. I also do not know. It requires further study on my part also. It's great insights into the topic by Sri Patil because of his insights and great experience, practical experience of handling several cases of this nature. It was a wonderful experience and an education for all of us. Thank you.
Thank you, everyone.
Thank you, sir.
And thank you, Mr. Patil, once again, and Mr. Vikram for connecting with us. Thank you, everyone. Stay safe, stay blessed.
Thank you all.